Welcome to Hot Topics When Medical Conditions Impact Work. This program is all about when systems collide, navigating through disability, workers' comp, and accommodation duties in California schools. And what we hope to look at is to enlighten you, heighten your awareness of what can go wrong and what should go right. And so today's focus is not policy per se, but it is about decision making under pressure when medical conditions do impact work. Whether it's in school districts or wherever you might work, decisions are often made through a single line or lens, so to speak, oftentimes with just that focus on workers' compensation. However, there are other laws that apply, and this is where we hope to illuminate what those possibilities look like and how to navigate all of them safely and effectively for you and your employees. And so, first of all, when we talk about policies for one and then laws, then there's also local decision making that comes into play. And so setting that umbrella, that big picture becomes very important as we look at these different situations. And so we want to start off with when the interactive process may be considered a legal problem. And so Felicia, thank you so much for joining me, my co-host and partner in this experience. Thank you, Felicia, for being here.
Happy to be here and happy spring to everybody. I know for all the spring breakers that have been off of school. So
yes, people are some back to work or some are just getting back to school. So yes. So the first one we want to talk about is that, again, that what is the interactive process? We still get questions, even in 2026. Do we need to hold an IPM? Felicia, just your comments about that.
yes, I know we're going to get to our first topic in a minute about does retirement end work comp case and TD benefits. But yes, certainly always when in doubt, we want to hold an IPM. We want to do them as soon as we can. And of course, as we always talk about, it's an ongoing process and continue that discussion. Keep the lines of communication open. Someone was asking me the most important feature of having a good relationship between a school district and their third-party administrator or their insurance carrier, whatever situation you may have. And it's excellent communication, like it is in so many things, right? Because there are a lot of things to consider, especially when we get to our first topic on retirement. That's one of the big things to consider.
Yes. And I'd like to just add to that, Felicia, before we dive deeper, is that, you hit the mark right on the head, relationship and communication, because when that relationship falls apart, that's when people get upset about their rights and fair treatment. And that's when legal action can take place, when people don't feel treated right. And we have a history of that in this country and all over the world for that matter. And so having that good relationship and keeping in communication about people's lives, their livelihood, their employment, their financial status is critical, because otherwise fear drives poor decision making.
Yes,
okay.
Certainly.
So tell us about your first case, Felicia, with the retirement issue.
Well, we thought we'd talk about this, and I'm going to use a real case with no names mentioned. And I'll start out with the case, and then I'll talk a little bit about the interplay that's so important between retirement benefits, whether we're talking about CalPERS or CalSTRS or another retirement system, and the workers' comp laws, and then all of the ADA, FEHA, and EEOC laws. The interplay is really complicated, and it is hard to be an expert on all of those things. So you really have to reach out and use all the expertise that you have at, and you don't also want to make hasty decisions. And we'll see that in our first real example. So this is a real case from a school district with no names mentioned, of course. This involves a 59-year-old bus driver. He sustained an injury. He was stepping out of the bus and slipped and fell down to the ground, and he injured his right ankle and his back and his neck in a work comp injury in October of 2025. So about 6 months ago. which isn't a long time in workers' comp, but that's when the injury occurred. He obviously reported the injury to the school district and was referred out for medical treatment. And he's been getting physical therapy and chiropractic treatment for his back and his neck. And he was put in a boot for his ankle. And he was put on temporary work restrictions, with no commercial driving being one of the restrictions that we see a lot for the bus drivers. And that unfortunately led them to make the decision that he wasn't able to come back to work under their return to work program, or in their transportation department or alternative work. They weren't able to put him anywhere. So he's been off work since October of 2025. Well, around in November, the district started talking to the employee about retirement. He has worked there this is an over 25-year employee. So certainly from a service year standpoint, he is eligible for retirement, right? And he was in a real critical need position, like a lot of the districts, that bus drivers are valuable, hard to get, takes a long time for training, and they needed him back in his position. So they started talking to him about retirement, and he retired on December 1st of 2025, even though his injury is not in any way resolved, right? The comp claim, as we know, he's still off work, right? He's on TTD because they weren't able to find any temporary accommodated duty, or didn't have any temporary accommodated duty for him. And he's still treating, meaning he's still treating for the ankle injury, and he's still treating for the low back and the neck injury. And he's going to have MRIs, meaning it's not clear how serious any of these injuries are. So in no way is the work comp claim concluded. And so the district's comment was, in what they told him too, well, TD's going to stop because you're retiring. And that caused me to think that this might be a little point to use in this to explain how the work comp laws work, because that is not how they work. TD does not stop with your TPA or in your insurance company just because they have retired under CalPERS or CalSTRS or whatever retirement system they're under. In California, retirees can continue to receive TD benefits while on workers' comp, with a caveat. If an employee retires for all intents and purposes and has no willingness to work, the insurance company or TPA may argue that they aren't losing any wages, meaning they would have retired anyway, regardless of the injury, which could lead to a reduction or a stop in the TD benefits. So the reason for the retirement plays a significant role. And California courts often make a distinction between voluntary and involuntary retirement. Well, we would say, oh, well, you retired. Well, that's voluntary. But if the injury is severe enough for the employee to retire, the worker may have a strong claim for continuing on TD. However, if the retirement is for reasons unrelated to the work comp injury, meaning you were going to retire anyway on your birthday, or you were going to retire on your 25th anniversary, we have many dates that we're looking for as to when we're ready. Meaning if it was pre-planned anyway before the injury, and you can kind of show that, you can back that up, then the carrier may be able to limit or stop the work comp TD benefits. So this is a question, and a lot of times when I'm talking to our employees, whether they be CalPERS or CalSTRS members, I always tell them, you really need to check with CalSTRS or CalPERS and talk to them, because this affects affects your service credits. It affects, the amount of money you're making at the end. So there's a lot of interplay in between your workers' comp laws, your retirement laws, and then, all of your benefits under Ed Code that you have with the school district. So I always recommend that you meet with HR, but you also meet with CalPERS or CalSTRS or whoever your retirement system is before you make a decision to retire. If you have an ongoing, and this claim's litigated, this particular work comp claim is litigated. So he has an attorney, and that's why the carrier has not stopped TD, meaning that's what the school district said. Well, he retired December 1st. Why is TD still going on in April of 2026? And it's because of that law that I just discussed. So you cannot have the idea in your head that if the person you need to replace that position, that if they
Mhm.
retire, you can simply replace them and their work comp claim and TD benefits are going to stop, because that is not what California law is.
Right, right. Now, my understanding is, and I'm bringing this up to make sure I'm not under a mistaken assumption, is that though if an employee does retire, that may affect his rights under the education code for that 39-month rehire period. That
Yes.
ends if somebody retires, but it does not affect the workers' comp case if that is still a temporary disability status.
Correct. And it also affects their sick and vacation, right?
Right.
Because obviously our accrued sick can affects our service retirement, right?
Yes.
And also our vacation is paid out. So you're not accruing sick and vacation like you are when you're still out on disability. So I think that when you're in HR, you don't want to make a hasty decision to tell an employee, hey, you're qualified for retirement. You could get retirement, because a lot of people have difficulty living on workers' comp, right? Because sometimes, not always, after the 60 days of full paid ed code leave, they can sometimes have financial loss. And so
Right.
that's sometimes where we talk about voluntary, involuntary. A lot of this employee said directly that they felt that they were forced to retire, that they had no choice but to retire. This is the language that they're using, not
Yeah.
that they went to HR and said, I'd like to retire. They felt like they had to because they weren't able to come back to work and they were running out of their benefits and leave.
Yeah, yeah. I know when I'm facilitating IPM, I always, if circumstances are right, I always say, it's an option. You have to check into it, but you may elect to do that. Some people do, some people don't, but that's your option. And so to make sure that they have choices, because I know, again, I did a lot of research, of course, at one point, and the big driver, with all these different laws at the federal level, is to help people keep working so that they
Yes.
don't fall into that, disability benefit reliance, because it is a loss of income that only affects the individual, but also the entire family. And so the socioeconomic losses are huge. And so that's why all these things come together. I was just thinking as you were talking that, and this applies to a couple of different things we're talking about today, but it's like a dance, like if every, let's say you have a single partner, you and I are dancing, and then we come apart and now a group comes together, and then we're dancing, but it's all in sync, and so it's this interplay, as you were, that word that you used, and coordinating all of that, and what are all the different things we need to take into consideration here. So great. Thank you. That's a great way to kick off. Okay. And so the second one is about those delays in the interactive process and what it could cost employers if managed sequentially, not parallel or concurrently to workers' comp. And we see this happen, that oftentimes an IPM isn't held until someone reaches MMI. What are the consequences of that, Felicia?
I looked up a case. The case citing is Jensen versus Wells Fargo Bank, and this is a published case. And this lawsuit was filed by Leanne Jensen. This is public record, so we can talk about her, against Wells Fargo Bank. She was a branch bank manager, and she developed PTSD after an attempted bank robbery at the bank, and a work comp claim was filed. The lawsuit alleges violations of FEHA discharge and violation of policy. And it was kind of interesting because after she developed the PTSD, and we do see this, right, in traumas, we see this at the schools too. She really struggled to return to work as a branch manager in the branch. And what her doctor did was he cleared her to return to work in non-branch capacities, which, wow, don't we love that vague language? What does that mean? But that means you need to meet, right? They should have met right then as soon as they got that note. The employer saw that note and thought, okay, HR met with her and said, we're going to allow you to apply for other positions at Wells Fargo. And that basically was their attempt at an accommodation. That's
Well,
you go apply for other positions. Good luck with that. But that's kind of when I'm reading between the lines of what I was saying. And what the judgment said was that originally the court found a summary judgment in favor of Wells Fargo. This is in the beginning, asserting that her disability didn't substantially limit her ability to engage in major life activities and that she had been reasonably accommodated. However, the appellate court reversed the summary judgment, affirming and remanding the case for further proceedings. And what the court held was that there were genuine issues regarding her disability and whether the bank made reasonable accommodations. And they always kind of give employer tips at the end of these cases, these FEHA and EEOC cases. And they said that no IPM was held along the way, and that having someone just apply for different positions in your organization is not actually an IPM and engaging in the interactive process, and that the employee themselves is not completely responsible for finding suitable positions for them. They said when they got the doctor's clearance for her to work in non-branch capacities, there should have been a lot of discussion, because they said, think about what she could have done some duties from home, done some duties maybe not working out in the public in the branch. They could have gone to the doctor to clarify what does non-branch capacities mean?
yeah,
Because
yeah.
that we have seen these with the PTSD and the mental health. And I know we have another case where we're going to talk about this, so I don't want to step on that too much. But we've seen these cases where the work restrictions from the psychologists or the psychiatrists are so vague, like can't work under people, can't work around people. And we're going to discuss that in a little bit. But certainly that really means that you need to meet, and the employer is supposed to be engaging and coming up with the ideas, and merely telling an employee to go apply for open positions is not sufficient.
Yeah, absolutely. And so that's why, depending upon where things are going, and oftentimes we're talking about simply modified duty. And so I always let people know, it's like, well, if this doesn't work out for whatever reason, there are next steps. We assess your transferable skills. How else might your skills be applied to other positions? And that's where, as you know, that's where the employer is responsible for sort of transitioning the person into that position without open competition against other applicants. That was the big mistake that this particular employer did, is that, they basically made her apply. I mean, not that you don't apply, but you don't have to compete and be selected to be the best candidate when you're engaged in the interactive process.
And I forgot to include the most important part, which is why she filed the lawsuit. She was discharged, right? She was let go.
Yeah.
In that process, right? Not only because that's what happened before she litigated, was that the lawsuit alleged violation of FEHA discharge, meaning that they discharge her from her position without looking at alternatives, right?
Yeah, basically terminating for disability, and that's a no.
No, right.
Big no. Yep. Yeah. So again, holding that interactive process early on, getting a sense of the employee's recovery, also assessing, are there other alternative jobs that might be more appropriate now that you've had this medical condition? And what are your transferable skills? Because it's not a lot, but certainly I see it happen where people have been placed in temporary modified duty or temporary alternative duty, I should say, then, sharpen their skills and actually do qualify to meet the threshold necessary to move into that position. And now they have a whole new job. And so, that can be very exciting and lead to a whole new career path. And so very important to assess those transferable skills and what openings. Employers should always come ready to an IPM to talk about, well, what other openings exist? And as I like to also say on that point, is that the employer can offer anything. However, under workers' comp, the job has to meet a 15% threshold, and some other criteria like comparable shift and things like that. And ADE is not, and FEHA are not quite so specific as that, but they do also talk about being within a reasonable commute. And again, the whole idea is that as long as people keep working, that's the key point. It might mean a lesser income, but if it means continuing to work with, all your other rights and privileges as an employee, that's the goal. That's the goal.
And certainly what we know as a branch manager, she had a lot of transferable skills, right?
Yes, absolutely, absolutely. So, yes, too bad, Wells Fargo, you lost on that one, right?
I think
Yeah.
that case is still in litigation from what I could tell,
Oh, okay.
what I was reading.
Okay. Oh, and so I would like to just go on because I used to work on projects related to EEOC decisions. And so if she gets reinstated, it's back pay. And it
Mhm.
also usually requires, mass training for all supervisors and managers on how to appropriately handle these kinds of situations in the future, and not to mention financial penalties. So it's a very costly venture when we don't do things right in the initial phases with an interactive process. So know your business, HR. Yes. Okay. Well, this next one, sort of a little overlap with the case you talked about with PTSD. And this is a real case too. And again, no names and very interesting history. Again, a situation of where it's a bus driver again. And at some point back in 2023, things didn't go well between the employee and the director at the time, leading to stress claim. And so the stress claim was initially accepted. But the employee was, allowed to continue working after a while. And then that director did leave her position, retired, and a new director was hired. So the new director has been in position for a couple of years now. And however, because the former director is still in the area, has valuable skills, the district's been down for a while trying to hire new bus drivers and dispatch and all that kind of so forth. The employee, as they can do under the Ed Code, come back and do substitute work. And so this employee has filled in as a substitute bus driver, substitute dispatch, and even helped out in the office because of her extensive knowledge.
Right.
And so the treating doctor under workers' comp basically said this person can return to work but cannot work underneath his director. Well, you can imagine, first of all, if the director was still there, that would be a problem because there's only so many people in the transportation department. But then again, like
And
you said,
underneath mean around, right?
well, I'll get to that point. And so the new director's been in place, and the employee had, openly disclosed some of the past challenges, but also had made comments about, I'm so stressed out. I don't necessarily feel safe in working on mechanics affecting, school children, and then had made other comments that were not appropriate for the workplace. And so when I first consulted with the employer back in February, I said, well, I don't know if you are aware of this, but there's a whole nother law that I don't even think has been taken into consideration. And that's called AB 2053. And it basically is something that was passed a couple of years ago that was really designed to strengthen, the whole workplace violence, workplace bullying kind of things. And there's actually a specific list of behaviors that are identified under that as far as what constitutes workplace bullying that could lead to workplace violence. And as I heard some of the details, it's like, well, let me send you this information because he's falling into a few categories here. He'd even made some menacing acts towards the former director when in her role as a bus driver. And so employees were coming to report that we don't feel safe for this person to be working on our buses. We don't trust that the repairs he's doing. Now there's a lead mechanic, and then he's the other full-time mechanic, and then they have a couple of part-time mechanics. And again, it's a situation where sometimes the mechanics will actually fill in for bus drivers if they have a need. That's where the part-time bus drivers come in. And so it's been a very difficult workplace situation on many fronts, and not that there haven't been efforts to try to manage it. And then he claimed injury to his knee, which is accepted as a workers' comp case. So he's been recovering from that. And then he was referred by the third-party administrator for a QME, qualified medical examiner, for the psych case. Well, interestingly enough, the world collided with all these different things then. That the one is that the doctor for the knee did release him to work with him some limitations, but not significant. But then the QME results came back, claiming, based on that person's review, that the person's stress claim did not meet the 51% threshold for psych cases. And so here, after all these years of, basically 2.5 years of treating under workers' comp, and still having issues, it's like, okay, what's the quality of care here? Has he been going to care? To still have this level of issue is not usual. And then when we did hold the preliminary IPM, he was so stressed out he had to leave the meeting. So I was like, well, that doesn't bode well for returning to work.
Continue with the conversation.
Yeah. And when we attempted a follow-up after getting we knew he was going back to the doctor and for the knee, and we said, well, let's just wait until we know what those results are, because he couldn't be accommodated under the prior limitations. And at first he declined to attend because he said it just stresses him out. I say, well, that doesn't bode well for a safe return to work on the stress claim. But then he did attend. And each time he and his wife asserted that, no, it's not that he can't work underneath the director. Because I was sort of going, well, what's the deal then? Because the directors change. And he goes, well, I can't work around her at all. It's like, okay, well, that's not what the doctor said. That's not what the doctor said. And so the QME did recommend further ongoing psychological treatment. So there's still issues with that claim. Yeah. But again, this whole safety issue, it comes up on the threats towards others and not feeling safe and so forth. So it's just been an interesting turn of events, and still in progress. But it was interesting that here a psych claim under work comp suddenly becomes a non-work comp claim. And then the behaviors that he was demonstrating at work place others at risk for harm or injury. And so that's under the direct threat element. And, we always say we proceed with accommodations whenever possible, unless doing so would place somebody at risk, or place the employee at risk or others at risk for harm or injury for something that manifests from the medical condition. So very interesting twist of events. And so I'd like to hear your comments on that, Felicia.
Well, just from over 40 years of working with employers and working with school districts for over 18 years, the one thing I always tell them is the ADA FEHA IPM track is running along disabilities, and they don't really care whether they're workers' comp or not workers' comp. Workers' comp cares whether it's workers' comp, because they're either going to pay for it, or if it's non-industrial, it goes to group health. So I said, sometimes you'll have a case that starts out, they'll apply for workers' comp, but it goes into delay, right? Because they're trying to determine whether, and that means it's non-industrial during that period of time, unless they're picking it up during the delay. Usually they're kind of paying for benefits during the delay, but not usually time off work until a decision's made whether it's accepted or not. What I always tell them is you're still looking at disability and whether you can accommodate. We don't care whether it's industrial or not industrial. We're looking at the disability. So you're still working on that track. While they're in delay, really, it's kind of looking at it like it's non-industrial. That's how I tell them, kind of look at it like that. And then until a decision is made. But sometimes when a claim's accepted, whether from the beginning or after the delay period, more information can still come forth that can flip that to non-industrial. It doesn't happen a lot, but it does happen where more information comes to light, and that may change the decision on the claim, which is what happened. This claim now, from being accepted and all benefits being paid, is now being denied on a medical basis by the doctor, which means comp is going to stop paying, right? They're going to stop, but then it's going to go to group health or a fit for duty. You still have a psych person, and you still have the danger, and you still have the workplace violence, and you're starting to work with your advisory council on HR matters and legal matters. And you've got to work on that workplace violence prevention to make sure it doesn't erupt into something more dangerous, so that you're protecting all of the other employees as well. Then you're talking to loss control about your workplace violence prevention plan and the log that you're creating on the complaints. And then you're also talking with, hopefully, your liability people and your advisory council, because once comp is no longer involved, then you have a non-industrial medical condition. right?
Yeah.
And I tell them it's the same when a claim is in delay. It's what I call in limbo. It hasn't been accepted or denied. So it's not either, really, right? They're supposed to pay for treatment, a little bit of treatment until they make a decision. But the claim can also flip from being accepted to denied or denied to accepted. So it does make it really tricky for folks from the district side and from HR, realizing that a claim could be denied even after it's accepted. And same thing could be in this case, it's denied, or accepted after it's denied, right?
Yes, yes. And so one of the pending matters on the psych case then is that, going back to the doctor who said no work underneath, and the employee continues to assert he can't even work around. Well, if he can't work around that employee, again, we don't fire other employees. That means that employee's job is actually in limbo, because that totally removes all possibilities. So we're trying to get clarity from that doctor. Well, what do you mean? No work under, because the employee is saying something different, and we need this decision clarified.
Right. And what I always tell people too is once the claim, especially by the QME, once the claim has been determined to be denied, you almost have to look at the claim as like it's non-industrial. And
Yeah.
the doctors that are involved in that case are no longer really going to be the deciders of things on
Right.
disability. It's almost like you have to go to a fit for duty or do independent evaluation or talk to the treater. They need to start treating outside of the work comp system at that point. So it really upsets the apple cart because all of the notes that you have are from doctors that aren't going to be involved in the case anymore. So
Yeah.
it's
Yeah.
really,
In fact,
they're not
that's
going to be paid, right?
Yeah. In fact, that's where we are, is that we have it set up for fitness for duty now on the psych aspects, because, there's a lot of things this person has said that doesn't make it safe, and by his own admission. So yes, big case. We'll see where it goes. And so stay tuned on that one. Yep. Okay. And so, we always advocate, temporary work while someone's still recovering when possible. But this next case addresses what happens when temporary modified work actually delays someone's recovery or is perceived to delay recovery. And so I have an interesting case, a recent case where, again, there's been two injuries, physical injuries. And so one was in 2023, followed by another in 2024. And this is a teacher in a kinder class, so little folks, okay? And basically the employee ended up falling twice. So once it was to the knee, the other time it was to the upper back. And so the district very proactively and so forth returned her to modified duty, as soon as they could. And so the thing is, though, now stop and think about it. 2023, 2024, still not maximum medical improvement on either one. And so she continued doing temporary modified duty all of last year and into this year, and still not MMI. And so that's a problem. Most situations will recover, within 4 to 6 months, unless there's surgery, and then you can expect a little bit longer. But we're talking, we're approaching 2 years here, and so something is not right. And when we held the IPM not too long ago, the employee acknowledged that last year was really tough. So absenteeism has been an issue because she's had to go out because of pain levels. And others, including aides, are doing her duties for her. And the doctor's note came back, and it's been pretty consistent through all of this academic year, but one of them was no walking on squishy surfaces. And as you know, in a kinder class, that then there are usually, soft surfaces, rubber surfaces, to prevent from injury and falling and comfortable sitting space. And so it really wasn't safe. So it was, again, a direct threat issue to herself as well as others if she should fall and lose her balance again. And she had been reporting very high pain levels. And so at the IPM, I said, I really have to say, continuing one, you've gone a very extensive period of temporary modified duty, which way exceeds the typical standards. And I'll let you speak more to that, Felicia. But the other thing is that there was evidence because she did go off of work in November for FMLA for a family member medical condition. So she'd basically been off all of December, January, February, and was just coming back to work in March, which is when we held the IPM. And so she was reporting significant improvement, not working, not
Mhm.
working. So again, there's another indicator that thank you, employer, for good faith efforts,
Yes.
but this is not where it was serving anyone well. And now we have evidence that she clearly improved when she was off of work. Well, she had improved enough that when she went back to see one doctor for one of her conditions, he was, well, I want to release you to a full duty on a trial basis. And it's like, okay, well, that's pretty significant given the limitations that were in December. And then two, you've already been provided extensive temporary modified duty. And I said, I would actually recommend, waiting until you are maximum medical improvement, because it should be forthcoming then fairly quickly if you've improved as much as you have. But then we had another doctor who still had significant limitations. And then if I recall, she had seen a QME but that was in October. So granted, it was prior to this leave of absence for non-work related reasons, but those limitations still applied. So we have released the full duty trial basis. We still have significant limitations from two others. And I said, you can't do it. You can't do it. And so very interesting. And so I just said, this is, again, good faith effort, but this is where temporary modified duty has not been serving the employee's recovery and actually delaying the case.
Right. And this is where you really need to look at your return to work policies, right?
Mhm.
Like we've talked about, even an EOC doesn't state that you have to provide temporary accommodated duty beyond 6 months. And I will say that all of the school districts that I've worked with in the past have varying policies, right? Some have 90 days. We talked to one that even had 30 days of temporary light duty after an industrial or non-industrial disability, which is quite short, right? I would say most of them do the 60 with a meeting to see if they're improving to 60. And then we have some who have bargained with their unions to 90 plus 90 to 180. And I think that's the longest temporary accommodated duty I've seen. But we have seen a few cases where they've accidentally exceeded. And when I say exceeded, 2 years, and like this particular employee, like going on 3 years. And what that can do with the work comp claim is sort of keep it in what I call a suspended recovery stage, whereas MMI hasn't been reached, but it may have been had they exceeded the policy and then sent them home and then they were recovering because they weren't improving. It may have been that the work comp claim would have moved along faster. In some cases, leaving them on temporary modified duty for 2 and 3 years, which you and I know it's very hard to argue that you can't provide that forever because you've done it for so long. That's why, usually it's not recommended to provide temporary accommodated duty for that long of a time. But I think sometimes these cases get away, right? In that particular case, the school district has had, if I recall, a huge turnover in staff, both in HR and in the administrative staff and in the higher, management positions. And that obviously can cause people to fall between the cracks, which is what can happen. And then that actually delays all of the things from happening on the comp claim
Yes.
because
Yes.
you're sort of keeping them in temporary status but not a real permanent status,
Yeah.
right? So it's not resolving anything. Nothing's getting
Yeah.
resolved.
Yeah.
And the MMI, as you said, normally, even if you've had surgery, 9 to 12 months after a surgery is what we kind of
Mm.
look at. And you're right. Most claims, if you are a school district, 6 months, 4 to 6 months is what you should be looking at for MMI. Sometimes after surgery, there'll be 9 to 12 months. That's if you've had a fusion or
Mm.
something like a total hip or a total knee.
Yeah.
Even that's a long period of time. So when we're talking 2 and 3, 4 years, there definitely have complications of falling between the cracks. And because she was kind of continuing in this temporary suspended status for so long, it allowed this prolonging to go on, right? She would have
Yes.
been MMI long before had
Yeah.
she been off work.
Yeah. Yeah, yeah, and sort of another case I've been working with over this academic year was that, again, a teacher, it's one thing I love how dedicated people are to their
Yes.
jobs. Again, a kinder teacher had hurt her right dominant hand, and so it happened last spring, but then she was, considered able to come back to work, but immediately started having problems, and so we met early on and addressed accommodations to be provided, but the employee, I don't want to quit working. I love my job. I want to stay working. And so we worked with her over the fall. But again, in this case, the employer did stick to the 120 days, or actually 60 days of a temporary modified duty. And that's the other key point there, is that, do 60 if you can. It's not always available. It's not guaranteed, but if work is available and modified duties is appropriate without putting the person at risk, then reevaluate in improving, then you can go on for another 60 or 90 days, whatever your policy is. But if they're not improving, don't continue. That's a sign of, a red flag right there that continuing to work isn't helping. And so she was like kicking and screaming, but, I had to make the recommendations that, you've got policy, you're not improving. In fact, continuing to work was actually delaying her access to treatment because it was hard to schedule in her after school hours. And so come the first of the year, she did go off of work and really threw herself into physical therapy and found a great therapist. And guess what? She's released to full duty now, so we're doing it on a trial basis to make sure, because, with a kinder teacher, one of the things, is all kinds of, paper cutting and hand manipulation, doing all these activities for the young students. And so a lot of hand use, but she's, was demonstrating improvements. So look, we eased her in over the break with parent teacher conferences. And now I think it was just this week, actually, she came back to full duty with some transitional assistance and to make sure that she's doing okay. So that's where it really shows that it works. And the other one where it shows that, those good faith efforts of trying to keep people working are good, but sometimes not to everybody's best interest. So, yeah. So again, you have to evaluate, as we always say, on a case-by-case basis. And I will acknowledge that, because I've been working, with the ADA since it passed in 1990 and was doing bulk rehab before that, different capacity, but you and I know each other from those early days. And EEOC did make a decision about, temporary modified duty. I think it was a part of what led to the amendment in 97, where the same, what you already said, is that, if you go beyond those 6 months, you're starting to demonstrate that you can, it's a business practice that you can live with that modified duty. Because I've seen this over so many cases, is that, you get a change in administration, say, well, that's just the way it is. We keep working with it, without questioning. And so things can slip through the cracks, but EEOC says, try to stay firm to that 180 days, because it's not easy. But it's doable for a short period of time. In 180 days, 6 months is considered a short, a reasonable time.
Yeah, it becomes harder to claim undue hardship, right? Or financial duress once you provided. In that case where you've done 2 or 3 years, becomes very difficult to argue that. And I know we've talked to many smaller school districts who don't have a written policy surrounding return to work at all, and not for industrial nor for non-industrial. And in my view, it should always be for both. It should never be singling out. I know I was talking to one school district and they said, well, we have a temporary accommodated duty policy, but it's only for our work comp injuries. And that is no go. You have a policy that applies to everyone that's hurt, whether it's cancer or MS or fall down on the bus or whatever it is. I don't care where the disability stems from, but everyone should have a policy that they have, vetted and that they have written down and that everybody knows about, that it's
because otherwise what you're doing is that you're discriminating against a certain type of medical condition versus a medical condition that doesn't meet that standard, i.e. workers' comp in this case. And so we've seen cases around that too. Yeah. And I'm just going to say one more point before we move into our last case, because it sort of ties back to our earlier case on alternative job openings. But I worked with a major employer. If I said the name, everybody would know it. And they had one section handling their workers' comp cases entirely separate from their non-work related medical conditions. And the danger in that is that then they had differential practices, and there was no overlap. There was no crossover between how they manage workers' comp and how they manage non-workers' comp. And so again, that is viewed as a differential, disparate treatment of employees who have medical conditions that are work-related versus non-work related. And so we've talked about this before on earlier podcasts, Felicia, about how important it is and this exists. I know that risk management oftentimes will handle workers' comp, human resources handles the non-workers' comp, but you gotta integrate. And I know with some of my employers, they have both representatives present, whatever meeting that we're holding, so that
I was talking with, that's a really great point, because I was talking with a school district and we were having a discussion about, they have HR handles all the non-industrial IPMs, and risk, because they have a risk department, handles the industrial IPMs. But risk and HR are not invited to each other's, right? And so sometimes they do very different things in the accommodation process, and one could almost say like disparate treatment. It's so different in the way that they're run, in the way that they're handled. And I said I said most of the districts, when they have a workers' comp IPM, they have HR involved in that, right?
Yeah.
And so or if they have the IPM over in HR, they have the work comp people there as well, because they know what's going on the work comp side. So you do have to have the requisite people attending.
Yeah, right. Yeah. And on that note, is that again, workers' comp deals with only workers' comp, but ADA and FEHA applies to all medical conditions. And so right there, you're running afoul if you're not paying attention to both of those. And additionally, sometimes we have cases where there's a work comp and a non-work comp situation. And so again, you need to marry the process together on behalf of that individual. And back to my psych case earlier, when we came back for the follow-up, work comp said that we would be dealing only with the knee injury. It's like, no, and the work comp is for your knee injury, but you have another very well documented medical condition.
All of your medical conditions, right?
Yes, yeah. And they were refusing initially to talk about the stress claim. I said, well, that's the no-go here. Any medical condition that's impacting your ability to be at work, stay at work and perform the work must be addressed. And that's under the state and federal law, FEHA and ADA, nothing to do with workers' comp.
It is a comp process, but I think that there's a lot of confusion. And I will say, in the work comp, the claims adjusters are not ADA and FEHA and EEOC experts, and nor should they be, right? That's not in their practice of expertise. But you're right, the IPMs don't have anything to do with, and we don't silo just work comp conditions. If they have underlying hypertension, or I know that one case we had there was a temperature. It was such an interesting claim. There was a comp claim, but there also was a non-industrial. If I remember right, the temperature of her classroom needed to be at a certain level because of a non-industrial condition. And those all got discussed together in the IPM, which they felt like needed to be siloed. And I said, no, we're talking about one person, right?
Yeah. So I know we can go on. There's all kinds of parallels I'd like to bring in, but for the interest of time and for our listeners, let's move on to our last topic. And this ties to our earlier when we talked about alternative job opportunities. And what happened in the Neiman Marcus group when they failed to address. So take it away, Felicia.
So this is kind of an interesting case, the Neiman Marcus case, and we'll talk about, they did a lot of things in this case to try to do the right thing. And so we'll talk about what ended up happening. This case is Nadav Ravro versus Neiman Marcus stores. She began working as a clothes fitter for the store in Dallas, Texas. And she was transferred to a fitter position in the San Francisco store here in California. And she had recurrent problems with back and joint pain. And her doctor informed the store that she needed various accommodations, including time off work and a shortened work week, which Neiman Marcus did provide. They did provide accommodated duty. And then the doctor informed Neiman Marcus that she had carpal tunnel syndrome in both hands and osteoarthritis in her fingers. And she requested FMLA for 1 month. And the employer asked the doctor, is the employee unable to perform work of any kind? And the doctor said yes. And when asked a list of essential functions of the job that she could not perform, the doctor wrote all, quote, right? This was his answer. And so, what Neiman Marcus did was they extended the FMLA leave as part of an accommodation also, right? So they provided some of the temporary accommodations and then they granted leave. And the doctor's note said she was unable to return to work, didn't list work restrictions on it. And she told the employer that she couldn't return to work as a fitter due to her disability. And she asked to be assigned to another position. And the doctor recommended, this is what the doctor's note wrote. The doctor recommended reassigning to a position that would not involve bending, standing, or kneeling. And Neiman Marcus told her to let them know when she felt she could return to work. And the doctor said she could return to work, but not in her previous position as a fitter. And then Neiman Marcus terminated her as she had exhausted all of her sick and her vacation leave benefits. And we see this a lot of times when they run out of everything, right? Their 100
Right.
days, their 60 days of Ed Code benefits. And she sued under FEHA for wrongful termination. And the court granted in Neiman Marcus' favor in this case. That's why I thought I'd present a case on the other side.
Yeah.
And the reasonable accommodations, they said that they provided in the beginning of the time off work and a shortened work week that they worked with. And then they also stated that the reasonable accommodation that they extended by 6 months, the FMLA leave. They gave her 6 additional months. And remember that 6 months we talked
Yeah.
about earlier. And they said Neiman Marcus was not required to wait indefinitely for her medical condition to improve so that she could return to work. So it was very interesting. Neiman Marcus was able to show all of the meetings that they had and all the things that they had done, and that they granted leave beyond even their normal policy to try to give her a little bit more time. And so that's why in this case, they found in her favor because they could show, and obviously, as we know, the granting of extended leave can be a temporary accommodation, right?
Yes, yes, absolutely, absolutely. It is a very interesting case, and I'm glad you brought that up because I have a very similar case too in a charter school where the employee presented a very unique non-work related medical condition, like in November. And the employee later filed before FEHA saying that they did not engage in an interactive process. And so the point I want to make is that Neiman Marcus demonstrated that they had, engaged her, were working with her, gave her leave, etc. And as is the other case, the employer did respond. They had a whole timeline of how they did respond, how they engaged, at least in communication, in response to each of her new medical notes that came in. She was claiming that they didn't engage in the process meeting in a timely fashion. And there's a difference. And I know I had another case where the union said, well, you didn't hold an IPM. I said, well, wait a minute. An IPM is a meeting. The process is a process. And so here the employer had been working with the employee, and as I emphasized in that case, is that, the limitations were fairly straightforward. The employer felt they could accommodate them and therefore they moved forward. There really wasn't a need to meet formally, but they were communicating and they were documenting. And the union rep was surprised. I said, well, no, I mean, the EEOC has said, if accommodations seem fairly straightforward, do it. You don't need a formal meeting per se, but you do need to document. And we've talked about that before, where documentation is so important. And so in both of my other cases I brought up, is that they definitely engaged in the process. They may not have held the meeting right away. And that's the other important thing. It sort of ties back to our very first topic. Well, not our first topic, but our second topic, delays in the interactive process. Again, if you're not communicating, then that's the problem. But the earlier you can have a meeting, if things are not going well, if it's not, really obvious about what's happening, then you should have a meeting to explain a whole lot of different things and get a feel for the situation and determine a course of action.
Right. And I'm reading in between the lines, obviously, on the summaries on these cases, but certainly in the Neiman Marcus, what you could tell, and even in my short little summary that I gave, there was a lot of back and forth between HR and the doctor, HR and the employee, getting clarification, getting notes, trying to see what they could do. They definitely showed a pattern of trying to do their best and trying to temporarily accommodate from the beginning. And then obviously when doctor's note saying that she can't do any essential functions and that she can't work at all, then they gave extended leave, to try. They did discharge her after the extended leave was over. And but all of these things, they were able to show their process, right?
Yeah.
It's not like they met 20 times, but you can tell that there was so much communication back and forth that they really made a good faith effort to try to accommodate her, and they could show, right?
Yeah. So a lot of interesting scenarios. It never ceases to amaze me, Felicia, about how many different nuances, twists and turns that cases can go, and just underlying the point of always you have to evaluate each case on a case by case basis. You want your process to be similar and consistent, but the outcome is always going to differ depending upon the employee's limitations, their job, and any point in time.
I always ask school districts, whether I'm talking with the workers' comp or HR or risk, who is the employee whose responsibility it is to manage employees with disabilities return to work process. And if anybody looks at me like they don't know what I'm talking about, I said, we need that there should be a definite answer to that question. That person has a process. They have a return to work policy. They meet with all employees that are on temporary accommodated duty. They're following that process. When school districts look at me like they don't know who that person is, or there are many people that might be doing some aspects of that, or there are 3 different people doing that. Right. It's not, then I know it's not being managed well, right? Then and there.
Yep. Definitely red flags that come up all over the place. Well, I just want to summarize.
Person that's doing that, right? They have a lot of helpers, but there should be somebody who wears that hat, right? I'm the return.
Providing oversight. And so I know that a number of school districts, I've worked with have, now created a new position to deal with that, to take the load off of everybody else, but also to have it more centralized. And so that's really made a big difference for those school districts that have taken that approach, sort of that crossover between, risk and human resources.
I know some districts will tell me, well, all of our supervisors make those decisions independently in their own departments. And I'm just like, no, all the supervisors do not have the necessary experience and expertise to be making those decisions. They make the decisions who comes back to work and who doesn't, and whether there's modified duty available or not, and whether they come back to work on alternative duty or not. And I'm like, no. If you've got 30 different supervisors or managers, they all are making the decisions. So it's got to be more streamlined than that, right?
Yeah, absolutely. And there have definitely been cases around that. So, yeah. So just to summarize really quickly, our 5 topics for today, retirement, ending a workers' comp benefit, no. What happens when there are delays in the interactive process? When they're managed sequentially and not parallel. Again, obviously laws exist, but make it like a dance, a joint dance, And then what happens when the work comp psych claim shifts? You still deal with the psych claim. It doesn't matter, but it is an interesting twist. And then also the implications for AB 2053 workplace violence. And then when temporary modified work might actually prolong recovery and MM status, and then missing that opportunity to evaluate alternative job openings. And we see what it costs Neiman Marcus, or didn't cost them. So thank you again, Felicia, for working with me to bring all this valuable information to our viewers and listeners. And we look forward to our next time.
Oh, it was a pleasure as always, Debra.
Thank you.